Everybody has an issue.
Yes, Your Honor. The state intended we call a witness now, but then we would play the video of Mr. Kelsey Kinard, and we would ask the court, we would make a motion to play prior recorded testimony due to his unavailability, and I didn't know whether you want to take up that testimony now so that way we can move into it, or whether you want to take another break.
The defense dispute that Mr. Kinard's unavailable.
No, if Mr. Duke says that he's unavailable, then we'll accept that.
Okay. I think based upon the motion that I signed off on for the material witness warrant and stipulation of counsel will accept that Mr. Kinard is currently unavailable despite efforts by the state to get him here. What did y'all figure out on Boccio's part?
We also have a second video for Boccio that has the few questions from Mr. Prince, and then the follow-up rebuttal questions by the state that's been recorded. It's a 2-minute video. We're anticipating playing that. There also is a stipulation we have regarding Mr. Kinard. He, following his testimony, got a reduction in sentence. We have a stipulation for that.
You have that?
Mr. Prince is that. This is just for record purposes. What I have in my hand, I want to mark it a court exhibit. This is the documentation that we did to get to try and get Mr. Kinard here, just for record purposes. That does not go back to the jury.
There's one additional issue that I would raise. I didn't have a chance to talk to Mr. Dukes about it because I just found out a second ago. Apparently there was a jury question for Mr. Kinard last time where he was asked what type of firearm, and he said he thinks it was a 9mm, which is obviously important testimony.
Is this mic on, Judge?
What?
Is his mic?
No.
I missed that one, so did I. We both missed that. I would just propose if we could have a few seconds, I'm sure we can figure out a stipulation to address that rather than trying to edit that in.
Or if we take a break after I play it, that I can run upstairs and re-record it. It literally is 3 minutes.
Why don't we just announce to the jury what was said rather than get into all that? We're just killing time.
Yeah, for the transcript.
And I will say there was also a follow-up jury question that the court asked, and this was the question and answer.
I'm no objection to that, Your Honor.
All right, so we're going to tell them Mr. Kinard is unavailable and trying to decide what to tell them about Boccio. I think it's really just a kind of a fairness issue. I think I'd say rather than requiring Sergeant Boccio to come back up here, we just decided we published his prior statement on this subject. Everybody okay with that?
Yes, Your Honor.
Yes, sir, that's fine.
Okay. All right, 7 please.
All rise for the jury.
We're going to do the video first.
I'm sorry?
Were you going to do the video
No,
first?
Dr. McElfresh.
Oh, okay, okay. All right, you remain under oath, Dr. McElfresh. You
All right.
can have a seat.
Thank you.
State your name again for the record, please.
Kevin McElfresh.
Hold on here. So you're not disputing it, I don't like it. Good afternoon again, sir.
Good afternoon.
Dr. McElfresh, in your duties in contract, I guess, with the state in order on this particular case, were you also asked at some point to do a comparison between a buccal swab that came from Angel Avila and compare it against a phone cradle? And that buccal swab would be defense exhibit number 10. The phone cradle is defense exhibit number...
You're looking at that kind of humble.
I'm sorry. And defense exhibit, electropharogram would be defense exhibit number 12.
Yes, sir.
And did you perform that comparison?
I did.
What is this?
I'm sorry, that's the wrong one. That's the ground law. Okay, let me rephrase it. You asked to do a comparison of a buckle swab from Angel Avila
Yes,
and compare it to an electropharogram that is exhibited here in Defense Exhibit 1A and B, which would be from a foam cradle, correct?
correct.
Okay. So let's talk about what we're looking at in this particular case. Whenever you first analyze what you see here in Exhibit 1A and B, this was not developed by you, it was developed by Joe Allen Brown, correct? The electropharogram?
That's correct.
All right. So as well as the buccal swab was developed additionally by Florida Department of Law Enforcement, correct? You didn't develop that as well?
That's correct.
Okay, but then you got the results of those and did the comparison?
That is correct also.
Okay. When you first take a look, and I know we talked about your normal procedure that you utilize when we talked about the grab bar, but in this particular case, we're talking about this exhibit right here. How do you go about first analyzing this and making determinations?
Well, the first thing you have to do is look at the electropharogram and get a good sense of what the results are telling you. And by that I mean, do you have a lot of DNA? Do you have a mixture? How many people are in the mixture? And then whether or not you have a major or minor component. Because all of those things, especially in a mixture, become important as you begin to interpret what that mixture might mean. So for example, if you determine that this is a 2-person mixture and you really have no data for it to be a 3 or a 4-person mixture or other extraneous data that you can't explain, then you have to look at your reference samples eventually, and you have to decide what makes sense and what doesn't make sense. And all of that needs to fit together as a composite whole. What you don't want to have to do is start invoking exceptions, if you will, that require you to say, well, I really think it's this, but I'm going to ignore this other thing for a while and see if I can come up with explanations. The objective here is to gather the data from the mixture itself.
Okay.
Do your comparisons and then see how the data fits. You're not fitting data to comparisons, you're fitting the comparisons to your data.
Okay. So as it relates to Defense 1A and B, did you make a determination whether or not this is a single source or a mixture?
It's a mixture sample of 2 individuals.
Okay. How do you make that determination in looking at this electropharogram that there are 2 individuals? Could there, okay, okay, good.
Okay, this is basic genetics, okay? We get half of our DNA from our mom and half of our DNA from dad. So in a situation where you see, for example, where you see these 2 large peaks right here, those are likely to be from a single individual, and one of those peaks came from mom and one of those peaks came from dad. If we see more than 2 peaks at a specific locus, then there has to be more than 1 individual there. If it's more than 2 and 4 or less, then it's 2, right? And you just simply work through multiples of 2, but it's not quite that simple. Because, for example, like I discussed when I was here last, brown eyes are fairly common in the population. So I might expect that in some instances, I would only get 3 or 2 peaks, even though I might have 2 individuals with the same 2 peaks, because everybody had brown eyes. So you have to look through all of the data, and you look through the entire data set and get the story of the data. And when you determine it's 2, it's because you've looked at all of this data in composite, and nowhere do you see more than 4 peaks.
Okay.
So it's collective data.
All right. And so nowhere in 1A or B do you find any more than 4 peaks that would be indicative of a mixture containing more than 2 persons?
Correct.
Okay. And in fact, that was the determination that Joe Ellen Brown initially made and noted on the bottom of this, correct?
Correct.
Okay.
Is it possible this is a mixture of more than two persons?
Unlikely. The problem is the population genetics piece comes in. And at some of the loci, like D21S11, for example, this locus happens to have what you could think of as a very high information content. That is, there are a lot of alleles at this locus, and they're very different between individuals. So that if I had a mixture of 3 or 4 people, I would expect to see many more peaks there than I see in this particular result. And the same is true for a number of other loci where you have very high information content relative to some loci like TH01 or sometimes CSF has a low information content.
That's CSF, TX01, what?
Those are all loci names that you'll see on the electropharogram. These are the names like FGA. There's D21S11 there. And so all of those, you can see we only have 2 peaks. And in fact, because we only see 2 at D21S11, this tends to indicate to me, in addition to having these being very small, that there might be missing data there. But nonetheless, you're looking at all the data collectively, and there's just no place that you can look at and say, well, this really could indicate more than 2. So this is a 2-person mixture.
Okay. So when you do this, do you also make a determination? I noticed that up here we have, where we were talking about earlier, we have the 4 peaks. 2 of them appear to be the same, and 2 of them are pretty close to being the same as well, but different sizes. What does that indicate? What are we talking about there?
What we're talking about there is what's called a major and a minor profile. And basically what this means is that we would expect when we're looking at comparisons that we're going to see one individual that has a profile that is, I can see mine down here, that would be 15, 18, and the other person is going to have a profile that is more the 14, 17, right? So one person's contributed more DNA than the other person, so we're going to see more of their peaks than we are the other person.
Okay. And did you go back and make a comparison earlier? We had shown you looked at State's Exhibit number 148, which is all of the results as it was of the victims as well as Mr. Segura. Did you go back and take a look at this and make a determination as to any of those being the major contributors?
Yes. When I looked at this, what I saw was that we had the major contributor was most likely Brandy Peters.
Okay.
That her DNA, you can see the 15, 17 here. Her DNA tends to be those large peaks, so that would appear to be her profile. And then at VWA that you just pointed out, again, she's the 15, 18, which are these 2 tall peaks.
Okay. All right. So if we found this to be a 2-person a mixture, that leaves those other 2 peaks as the other person. Would that be fair to say?
Yes, that's correct.
Okay. So whenever you're examining this and comparing it against Angela, well, let me ask this. Were you able to rule out whether or not Tamaya, Tanaya, Peters, Javante Segura, and Henry Segura were a part of this mixture?
Yes, they tended to be excluded from this, but this data is not as complete as it could be, so it was difficult to do some of those exclusions. Tamaya, Tanaya tended to have DNA that was in the mixture, but they would have been masked by Brandy at most of those locations. Similarly, when I looked at Mr. Segura, it would appear he was not in the mixture because there were places where his DNA was missing.
Okay, just so we're clear then, did you find that Tanaya and Tamaya were a part of this mixture or not?
I couldn't really determine conclusively whether they were.
Okay. All right. So then let's take a look then. Did you also compare Mr. Avila's testimony? Or I'm sorry, Mr. Avila's DNA?
I did compare his DNA, yes.
Okay, and did you make any determinations about whether Mr. Avila is present in this particular case?
He is excluded from being a part of this mixture.
Why?
First of all, there are a number of places where his DNA is simply missing. That is, when I look at it, if he was there, I would expect to see his DNA, and I don't. And then when you take that into account and you begin at looking other locations, so for example, at VWA, where we were just talking about, Mr. Avila is a 17-18, okay? So, but the problem is the minor component here is a 14-17. There's no 18 at all. So you have to argue that somehow his DNA is partial.
All right, let me stop you there. There's no 18. I thought right here it says there's a major that's an 18.
I'm sorry. Let me look again. I'm sorry, it's the wrong combination is what I'm trying to say. The minor combination is the 14-17,
Okay.
not the 17, not the 17-18. Okay? That's
So
what I'm
you're
trying.
talking about the combination of the two smaller pieces
Right.
that you're talking about.
The smaller combination is 14-17 here.
Okay.
Okay, so that's the DNA pattern that I'm looking for to be part of that, and he's not. And the problem compounds itself, because if you say, well, he does have a 17-18, and there's a 17-18 there, but one of them's the tall peak and one of them's the minor peak, then this has to be a three-person mixture, right? Because we haven't explained this other peak over here. And we have to say, well, somehow that this minor combination that appears to be a combination of a single individual is in fact multiple individuals combined differently than we see it in the data. We have to effectively invoke an exception here.
I don't understand at all what you just said. So you are saying, earlier we talked about this being a two-person mixture, and you're talking about in order to explain that 14, you've made a determination that it's actually a three-person mixture?
No, you would, in order for you to invoke the explanation that this 14 and 17 were somehow indicative of a person who could be a 14-15, or that we have a 17-18 combination that's out of balance like this, means that you have to suggest there's a third person, because you haven't explained all the data. Whereas if you say this data is the two prominent peaks of 15-18 and the two minor peaks of 14-17, you have a consistent answer. It's consistent with the two-person mixture. It's consistent with Mr. Avila being excluded and his DNA not being in that mixture. So then you have all of your data lines up. It's a two-person mixture. Mr. Avila is excluded. And while we haven't identified the 14-17, this 14-17 nonetheless isn't indicative of Mr. Avila. If you try to make his data part of this, then what happens is you have to have these two peaks that are imbalanced, which leaves the other peak sitting outside unexplained, and the only way to say it is explained is now to invoke a third person. And we don't have any data for three people.
Okay, let me make sure I understand you here. So Mr. Avila, if we look at what the data says as being a two-person mixture, because you have four peaks and nowhere else in the electropharogram is there indication of a third donor by a fifth, sixth peak.
Correct.
We are looking at a two-person mixture.
That's correct.
And because we're looking at a two-person mixture, as finding Brandy Peters as the major donor at a 15 and 18, and Mr. Avila would be a 17, 18, excuse me, I'm looking at the wrong chart. A 17, 18, that 14 is left unexplained, and therefore, because of that, it cannot be Angel Avila.
That's correct.
Okay. Now, in order to get that to be explained, or include Mr. Avila, you would then have to assume a third-party donation there that is not reflected in any other data that's in this electronic paragram. Is that what you're trying to say?
That's exactly what I'm trying to say.
Okay. Well, let me ask you a question. if someone were to exclude Tamaya and Tanaya for part of this mixture, okay, there's a finding of an exclusion that Tamaya and Tanaya aren't a part of this, but that Tamaya and Tanaya carried a 14 allele at that location, at loci, at VWA. Could you then include it to try and explain away that 14?
No, you don't get to exclude somebody but say, well, I might see a little bit of them. And
Why
once, well, partially because all of your DNA is there or not, even if you have an incomplete pattern. There's enough information in these electropherograms. We have RFU values over 1,000 in some instances, where we just don't see their DNA where we should. So once you don't see it, then that explanation's out. That's not available to you.
Okay.
And again, this is where what you have to do is look at the data and let your data lead you to the explanation rather than the explanation lead you to the data.
I think that what you're talking about is like an analysis bias.
It can be. The difficulty in all of these kinds of analyses are that you have the combination of genetics, population genetics, the interpretation, knowing what the background of these alleles are and these loci, and it is possible to get completely confused trying to figure out if any of the data makes sense. And so you end up having to step back again and again as you begin working on the data and working through it. Step back, look at the raw data, go back, make some comparisons, step back, look at the raw data and say, do these comparisons make sense? Go back to the raw data. It's very iterative as you work through this information. This is why interpretation guidelines can be very restrictive for some laboratory systems because of exactly this problem.
Okay. So in this particular case, Joe Allen Brown makes a determination that the minor is a 14-17 and Mr. Avila is a 17-18, Brandy is a 15-18, and that leaves that 14 unexplained and therefore would exclude Mr. Avila.
That's correct.
Is that the only spot that we're talking about with Mr. Avila and excluding him in that situation?
Mr. Avila is what at that point?
Mr. Avila at
Let's let
the
the witness.
I'm sorry.
He is a 17, 18 at that location. And
Mr. Fuchs said 14, 17.
I believe what I was trying to say is that Joe Allen Brown made a determination that the minor was a 14-17. Mr. Avila is in fact a 17-18.
That's not what you said.
Okay. Thank you, Your Honor.
Correct.
Thank you.
actually, this exchange is exactly indicative of how you have to sort of iteratively work through these kinds of results, because you're dealing with 14, 15, 17, 18, and those combinations. And it actually makes the math somewhat complicated when you do include somebody, because you're effectively having to work through possible combinations versus real combinations. And that's often what happens is people will say, well, I can maybe include this person, but then I have to invoke a different explanation. What you have to be careful of is not doing that, but coming up with a comprehensive data analysis.
Okay. So let's also take a look, if we can, real quick at D5, which is this one right here, correct?
Yes.
All right. In this one, Ms. Brown determined that the major was an 11-11,
Yes.
and that is same as Brandy Peters, correct?
Yes.
And then she made a determination that they are start alleles, but that the minor was a 7 and a 12, correct?
That is correct.
Okay. Is Mr. Avila a 7 and a 12?
No, he's an 11-12.
So again, we have a 7 allele here that is part of this mission identified as the minor contributor that is not consistent with Mr. Avila's
That's correct.
DNA. Okay. So we have two specific spots right there where minors are determined that are not consistent with Mr. Avila's DNA. Does that eliminate him as being a sample, the contributor to the minor DNA?
Yes, yes, that's exactly one of the things that eliminates him.
Is there anything else that eliminates him?
Just a moment here. Once again, if you look at locus TPOX, we
That's the same page?
yes, that's on page 2. That we colloquially refer to that as TPOX. It's a very similar situation.
Right here?
Yes.
Okay.
Okay, you have an 8-9 as your major profile identified. The minor is 9+, but you'll see that designation 9+ means I see a minor peak there at 9. There might be something else, but I'm not sure. Well, the problem here is that Mr. Avila at TPOX is 911, okay? And you can see there's no 11 at all, right? There's simply no data for an 11, which is his allele. And that's one of the things you look for is, okay, even if I explain some things as being either stacked or covered up by having the same allele as the major, here's a place where he has an allele that just isn't there. And you either have to invoke dropout, which could be an explanation, but in light of all the other data that you see, it's also more consistent with him being non-contributor to the sample.
Okay. So we have VWA, D5, and TPOX. Anything else?
Let me just check quickly my notes. The same situation for D18, S51. If you look at that locus, and I apologize, we're back on page 1. Right, and this is this locus right here. So again, we have a major at 17, 19. The minor is 18. And for this locus, he's a 15, 18. And we don't have the 15, right? There's an 18 there, but we don't have any 15 down here, which would be right in this area here, called by the computer. So again, when you start saying, if I argue and conclude that he's excluded in this sample, this is another indication where here's an allele that should be there that isn't. And that is consistent when you take all of this information together that we've been talking about. The most reasonable explanation is he's excluded from this sample.
Okay. And that's an important point, obviously, is that you can't just take each one of these alleles individually. You have to look at all of it as a whole, correct, in order to make these determinations?
Yes, and that's a very important point. All of this data, you have to consider everything you're looking at as a whole. You can't pick and choose. And you can't invoke, for example, the explanation you mentioned earlier that, well, maybe this one peak is actually contributed by a person who I said isn't there, but I'm just only seeing this one location. that's inconsistent with the rest of the data we see here. And this is a complex mixture, that's clear, but it isn't impossible to interpret. You just have to be careful that you come up with a consistent answer that works through all the data.
Okay. And the consistent answer that you determine is a two-party donor, there's a two-party mixture, and that Mr. Avila is not present in this mixture, correct?
That is correct.
No further questions.
Just a few questions. I'm not going to dive way back into the nuance of the interpretation here. You indicated we have to look at the data set as a whole, correct?
Correct.
And when you mean the data set as a whole, you mean this specific electropharogram. You're not taking into account what other findings may have been made on related items. And let me be a little more precise about what I'm asking, I guess. This was a profile developed from the swab of a phone cradle, correct?
Yes.
And so you're not going to take into account whose DNA is on the handset that goes with that phone cradle or the cord that goes with the phone cradle, correct?
That's correct.
Okay. And you said to do the best interpretation here, you want to try to avoid invoking exceptions like dropout and like masking. Did I understand that correctly?
You want to avoid those explanations as best you can. If those explanations become the overriding explanation, if dropout is the explanation you're invoking everywhere, at some point you have to say, I'm sorry, this sample's inconclusive. So it's a balance. It's a balance between the data you have, the data that could be there but isn't showing up, and the results from the comparisons.
Okay. And to be clear, though, dropout is prevalent throughout this complex mixture, correct?
There is dropout.
And likewise, there could be masking going on as well, correct?
There could be, yes.
Okay. So I guess the phrase exception, to be clear, doesn't mean exactly the same thing. It does in normal vernacular. You refer to those things as exceptions, but at least as it pertains to dropout, for example, we know that is in fact occurring with this sample, right?
It is a factor occurring with the sample. So what you have to do is, like I showed a minute ago, look for areas where you can see data and that data is inconsistent with an individual or includes an individual. In this case, it excludes Mr. Avila.
And I think you were referring to TPOCs on the co-filer page where you're talking about only 3 allele were showing up, right?
Correct.
All in low RFU value, correct?
That's correct.
And so unless, for example, an allele is being masked at that locus, then we're dealing with dropout there again, correct?
Not necessarily. It depends on what the other contributor's DNA is.
Let me go back to that one real quick so the jury can see what you and I are talking about.
Yes, good idea. I think.
So at TPOC, there's a third locus.
Which one you're referring to?
This one?
That one right there, yes.
Okay.
It's the 8, 9, and 10 alleles.
So either dropout or masking has to be taking place there, correct? Because nobody has one allele at any locus, correct?
Exactly the point. That isn't there, and that excludes Mr. Avila.
What my point is that either dropout is going on at that locus or masking is going on, because there's only 3 numbers and we know there's 2 contributors, right?
There's 2 contributors, and it could be that there's an 8, 10 is your major. It could be, you notice that this 8, right? That 8, let me make sure, yeah. That 8 could be compared, right? Because this peak, this 8 peak is higher than the 10 peak. So we have the 9 down here, we're missing 11. It could be that that 8 is masking, and so you have an 8, 9, 8, 10. So that's consistent with a 2-person mixture. But what we don't have is the 11.
Well, you've told us before, a minor deviation in RFU value, like we're talking about here, less than 200 RFUs difference between the 8 and the 10 there, that may not necessarily mean that another allele is being masked, correct? There could be another allele number that's just dropping off right there. Is that correct?
It is possible, yes.
Okay.
I didn't quite follow your math on that, Mr. Prince.
Yes, sir, let me
You're
clarify.
between 544 and 331, so it's,
Right.
I don't think that's 100. My math isn't great, but I don't think that's 100.
No, I said about 200 RFUs.
Okay,
Difference
okay.
right there. That's statistically insignificant, a difference of about 200 RFU, right?
It is, but the problem here is that because of the level of DNA in this sample, and also the hard part is that you have to see that the scale on this is very high, relatively speaking, so that you're looking at 0 to, this is going to scale out at 1500 on the top, and we're looking at allele peaks of 544 and 331. So they're going to be compressed, so it's not as clear as it could be. And overall, this sample is not terribly imbalanced. So again,
It's not terribly what?
imbalanced.
Okay.
So because you've got a major and you've got a clear major, you can look at certain pieces of this. And again, this is how you you go in, you look at the sample, you look at comparisons, you step back. Does that comparison make sense? You go back and it's a very iterative, very intense process.
Okay. And you agree with the general principle that as you're reading an electropharogram from left to right, you're going to get lower quantitative values for the biological material showing up as you go across, correct?
Yes, the PCR is less efficient as the DNA fragment length gets longer.
And so that's why we see these RFU values going from amylogen and across the CFS, they're consistently dropping, right?
Typically, yes, but you'll notice that in some of these reactions, this is called a multiplex reaction. So you have many reactions going on at the same time in the reaction tube. And because of that, some will in fact decrease in value, but some maintain pretty stable. This was true for the profiler, co-filer kits in particular.
And that's going to be the case sometimes when you're dealing with relatively low RFU values, touch DNA, correct? A lot of times you'll see slight variation where a locus to the right will have higher RFU values than the one to its left. Is that correct?
Yes, I think you said that right.
Yes.
I was trying to follow you there. The point is that typically this is the lowest molecular weight DNA in the reaction, and these are the highest molecular weight DNAs. And as we proceed from this point to this point, we will see some drop in RFU values because the overall reaction efficiency drops some.
Okay. So bottom line is you're not comfortable saying that the twins, for example, are kicking in at certain locus with respect to this mixture. The simplest explanation from your perspective, so that you can avoid calling masking or calling dropout, which you've identified as exceptions, is just to say this is a clean two-donor mixture and Mr. Avila is excluded.
It is a two-person mixture and Mr. Avila is excluded.
Okay. And to be clear, there's the minor contributor to this mixture is a male, correct? Because we see at amylogen and there's male DNA present, right?
There is some male DNA, and as you can see right here, because females have 2 X chromosomes and male 1, this is roughly a 3-to-1, if not 4-to-1 relationship. So you're looking at some male DNA, but not very much.
Which is why the minor contributor relative to Brandy Peters, that's the person you would expect to be the male, correct?
That is the best explanation.
Okay. And I think I heard you indicate during direct, you said Mr. Segura is excluded as a contributor, which means Mr. Segura's DNA is not in this mixture, correct?
That's correct.
And similarly, Javante Segura is not a contributor to this mixture. He's also excluded, correct?
That's correct.
Okay. So in any event, this is a foreign male, that is a male contributing to the mixture that's not Javante Segura and not Henry Segura.
That's correct.
Thank you. I have no further questions.
Yeah.
Any juror have a question for this witness? You can sit down. How long is this video?
20 minutes. What's that? 22 minutes.
Okay. All right, next thing we're going to do, get gathered up. You're going to hear and see a video of an individual named Kelsey Kinard. The state has been unable to secure the attendance of Mr. Kinard despite extensive efforts to get him here. Therefore, we're going to present his prior testimony. You should consider this video as you would any other evidence. And you have a transcript to follow along also.
I do, Your Honor, give me one moment. Follow, Your Honor. Morning, sir.
Good morning.
Can you please introduce yourself to the jury?
Yes, I'm Kelsey Kinard.
Mr. Kinard, it's my understanding that you are actually in prison.
Yes, sir.
And how long have you been in prison?
11 years, about 2 months, 3 months.
During that term of imprisonment, were you in Oklahoma City back in 2011?
Yes, sir.
During that time period, did you have a cellmate by the name of Henry Segura?
Yes, sir.
Do you see here, Mr. Segura here in the court today?
Yes, sir.
Could you please point him and indicate article of clothing he's wearing?
The guy in the yellow striped tie with the blue suit with glasses.
May the record please reflect what you indicated at these minutes, Mr. Segura. Mr. Kinard, during that time period, do you remember how many days or how long you were there with Mr. Segura?
I think if I'm not mistaken, roughly about a week.
Okay. During that time period, did you and Mr. Segura have an opportunity to talk, obviously?
Yes, sir.
While Mr. Segura was there and talking, did he ever talk about why it is that he's been arrested?
Yes, sir, he did.
Did he ever give you any information? What did he tell you about that?
Oh, he told me he was incarcerated for murder and that he was just being picked up from Minnesota, I think, if I'm not mistaken.
Okay. Did he give you, at any point, did Mr. Segura tell you anything about whether he did?
At first he kept talking about it, and then I kept telling him, like, don't tell me your case. And then the next day he kept talking about it, but after about the third day, yes, sir, he went in full details of what he was in, what he was charged with.
When you say the first time, the first 3 days, you tell him not to talk to you, was it saying anything at that point about specific?
Yeah, he told me that he was from Florida. He had killed 4 people and went to Minnesota. And I was like, oh, don't tell me your case. And I told him don't tell nobody your case.
They told you?
Yes, sir.
What did he tell you on the third day about that case?
Well, he had told me that he killed his baby moms for because him or her was going through some child support issues or something like that, and he was upset because she was obviously had more money than him, and she wouldn't take him off because he had a little boy or something by, and he killed her and the kids and everybody.
Okay. Did he give you, and so he says that there was a money issue having to do with child support.
Yes, sir.
And he was upset because she barely had more money. Did he give you any other details regarding it?
Well, if I'm not mistaken, he was like that. He knew that she was something with some drugs or something, and he tried to get her to take off child support, and she wouldn't. And he like, I just lost it.
Did he say anything about who was present, or how, let me ask that, did he say anything about how he was?
He shot her and one of the kids, and he drowned 2 of them.
Did he give you any information about why it is he would have shot 2 but then only drowned 2?
No, sir, he didn't.
Did he give you any information about, whether or not all 4 of those persons were there at the same time, or anything along those lines?
No, because like I said at first, I could tell it was bothering him, right? And then when he started telling it out, like, listen, I'm gonna do, you really don't wanna tell your case to like that, right? And so he kind of started stumbling around, but he was making rap songs about it too, so
What do you mean he was making rap songs about it?
he was actually rapping about it.
What was he saying in the rap?
How he had killed her and the kids, and he was nothing to be played with.
Did he make any statements to you about where he may or may not have hidden any kind of murder weapons or anything like that?
Yes, sir. He had I think a wife or something and at this time that the gun that he used was supposed to be at her house in an old car or something in the motor, or something to that nature.
Did he tell you anything about that kind of car or car?
No, sir.
Did he tell you anything else regarding these murders? The rap songs you're talking about, was that just one time or over time?
Nah, like for the whole week he was in there, he was making all kind of raps, but that one rap, he wrote several to him. I think I actually mailed him out to somebody, like his wife or somebody, because when he left him behind. And I had, like when you leave Oklahoma City, you can't take nothing with you. So I actually had to put my name on the mail and send it out to I think it was his wife or somebody.
Anything else he told you regarding these murders?
Yeah, it was this one girl he used to go with. He had went to her and asked her to buy a gun or something, and she denied it. She wanted to get the gun for him, and he was like, if he get out, he was gonna kill her too.
Did you just talk to him the one time? I know he had a rap, but did you just talk to him the one time about cases?
We spoke several, in that week, we spoke several times.
The information you're talking about, did that all come out at one time, or did it just over the course of that?
Over a course of that week.
At some point, did you tell law enforcement about the statement that Mr. Segura?
Yes, sir, I did.
Why did he tell law enforcement?
Well, for one, I'm a father. And 2, a part of my plea deal in the federal courthouse is that if I have any knowledge of any criminal activity and I don't report it, I could be prosecuted for that. That was part of my plea deal.
Okay. So you're doing this, one, to keep from being prosecuted,
Yes, sir.
and 2, you have children of your own.
Yes, sir.
Are you also looking to get benefit, maybe a sense of reduction?
Well, as you know, that the government can never promise you nothing, but it's an and/or situation. I could, but I couldn't.
Yeah. But you're hoping for it.
Yes, sir.
Based upon that, does that mean you're being untruthful?
No, sir.
Right.
Mr. Kinard, how many times at all have you been convicted of a felony offense?
I think 5.
And you've got 11 years served at this point. How much did you have served back in 2011? About 5 years or so?
No, actually, I received one time credit already. I had 16 years and 8 months, and they reduced it to 14 years.
So you were originally sentenced to 16 years,
Yes, sir.
and at some point it got reduced to 14 years.
Yes, sir.
Was that on a post-plea sentence reduction?
Again, my plea deal was if I had any criminal activities that I knew about, I was supposed to report it. So I did. At that time, they didn't give me nothing that sentence. So when they convicted the people that was involved with me at that time, they later reduced my sentence.
They reduced your sentence based on the government filing a motion for substantial assistance,
Yes, sir.
which you didn't have at the time of your plea.
Nah, I cooperated, but it's a process in the federal system that has to go through a whole lot of investigation, billing cases and things of that nature. And when you actually do get locked up, they might let that person out to cooperate. So when that person gets to cooperating, then they come in, they too receive a time cut, and then that's when I get mine as well.
So you were originally sentenced to 16 years. You got a time cut on a subsequently filed motion for substantial assistance, correct?
Yes, by the government.
And the government is the only party that can file a motion for substantial assistance, correct? That's your
No.
understanding?
No, I can file one if I feel like that my assistance that I turned over to the government was substantial enough. Yes, I can file one under a motion to compel the government and lay grounds out why. And then it's the government, which is my USA attorney, if she feel that my assistance was substantial enough, then she would grant me one.
You're aware, sir, that not even a federal judge can compel a U.S. attorney to file a motion for substantial assistance unless they're withholding it for like racial or gender reasons, right?
I mean, when I filed mine in 2011 and 12, that's what I filed down there, and the government told me if I withdraw, they would grant me mine. So that's what they did.
So they granted you one already,
Yes, sir.
and you're hoping for an additional sentence reduction.
Yes, sir.
And when you say you would be prosecuted, you're aware you wouldn't actually be prosecuted if you didn't tell them anything. A condition of your plea was that you testified truthfully, if called upon to do so, regarding criminal activity that you have knowledge of, correct?
Yes, sir.
Okay. So you're aware then that it's not actually a criminal offense to not proactively report a new offense?
Well, all I know is my plea agreement stated that, and that's what I must do.
Okay. So your understanding of your plea was that you would be charged with new offenses if you didn't come forward?
Yes.
Okay. I noticed when Mr. Fuchs asked you why you were coming forward, first thing you mentioned is that you're a father, and he had to kind of drag out of you that you want a sentence reduction. Why were you hesitant to give that information?
Well, I don't think I was.
But he asked you why, you gave two answers. The fact that you were there. Yes, sir. Yes, sir. Do you recall Mr. Fuchs asking you why you were here, why you were offering that information against Mr. Segura?
Yes, sir, I do.
Do you recall giving him two reasons, one of which was that you were a father?
Yes, sir, I do.
And it was only after he prompted you with an additional question, specifically about whether you were hoping to get a sentence reduction, that you admitted that.
Yes, sir.
Okay. So the question is, why did he have to specifically point to that? You were asked the question, why are you doing this? Why didn't you offer that information truthfully?
He didn't because, again, in the federal court system that we really don't have to turn that information over. I don't know how it works over here in the state, but in the federal system, we don't have to turn that information over because it's something that's already noted, and we don't have to turn that information over.
You don't have to turn what information over?
That we will receive a time cut. We don't have to state that for the record.
Are you saying it's your understanding you will receive a time cut?
No, I said that in the federal system, we do not have to state that we will receive a time cut, or we will or we won't. We don't have to state that.
I see.
We don't be asked those questions.
I see. Okay. Let me ask you about these raps that you say Mr. Segura wrote or sang. Was anybody else around when he did those raps?
He had several homeboys there that I also told him not to talk to his case about, but I can't, like, it's been a little while ago. There was 2 other dudes there from Florida at that point, and I can't remember their names and like, you know.
Okay, and so the 2 people who would have been able to corroborate your story about what Mr. Segura said, you never provided that information to law enforcement.
No, I didn't.
And likewise, the written rap that you say would have corroborated what he was saying about these offenses, you sent that off to his wife and also didn't provide that to law enforcement.
I think in my original letter I did, I told him that, because I wrote the courthouse, I told him that they can check my car log, because I not only sent letters to his house, I spoke to his wife. If you go back to 2011, you can see his phone numbers are on my list, where I called her several times for him and spoke with her while he was there and after he left.
My question is, you sent the rap that you claim he wrote to his wife, not to law enforcement, correct?
Yes, that's what he asked me to do with it, because he had other mail in there too.
And so all of the corroborative evidence that would have supported what you were saying, the other witnesses' names and rap is gone, right?
I sent it to his wife.
My question is, that evidence is gone,
I sent it to his wife.
okay? And likewise, didn't provide law enforcement with the names of people who could have corroborated your story. Is it true?
I sent it to his wife.
I saw that you mentioned during the questioning of Mr. Hughes, you said that you told Mr. Segura you're not a guy that he wants to be talking to about his case.
Yes, sir.
Are you somebody who, besides the time you've already told us about, when you got a 2-year sentence reduction, has either cooperated with the government or attempted to cooperate with the government to get a sentence reduction for yourself in the past?
Well, I never, his situation, I never ran across nobody like that, but yes, I have cooperated with the government on a high level, and it's never been a doubt about my cooperation.
So you're somebody who's eager to cooperate with the government?
No, I'm not eager, but again, my plea agreement stated that if I have criminal activity knowledge, I must turn it over.
Okay, so over what period of time have you been cooperating with the government, providing information to them about criminal offenses?
Oh, several years now on several cases.
How many cases?
I can remember correctly, like 3, 4, maybe.
Okay. Been to court to testify in those cases?
Yes,
Okay. Is that why you got the sentence reduction? You came to court and testified against the defendant in that other case?
yes, sir.
Okay.
But he actually pleaded out though, once he seen they had me, he actually pleaded out.
How many times have you attempted to provide assistance to the government? Meaning reach out and contact, or have your attorney reach out and contact somebody from the government to tell, hey, I've got information about another case for you?
Again, in the federal system, it works different. Once you turn the information over, it might be an ongoing case that they may not even use you because they might have enough people already, and then it could take years on down the line. So it could take maybe 10 years just to build this case on a certain individual. So it's probably still ongoing cases that I gave information on that they just haven't used me for yet.
My question is, how many times have you either provided information or attempted to provide information?
I can't give you an accurate number on that. It was several cases.
More than 10?
No,
You don't know how many times you've attempted to provide information?
no.
How many times you've provided information that hasn't come to fruition in the form of a motion for substantial assistance?
I can't give you an accurate number on that.
Isn't it true, Mr. Kinard, that the reason you said Mr. Segura shouldn't talk to you about what he was accused of doing, what he was alleged to do, is because you're somebody who takes information like that and uses it to try and put yourself in a better position with respect to sentencing?
No, I just give government the truth.
No further questions.
For your record, yes, Your Honor, actually, we must have a question to ask that to be more subtle before we call it a vote. Thank you. When Mr. Segura was there with you, did he go sleeping?
Yes, some nights he used to just wake up and you could hear him moaning and he'd just get up because we was allowed 2 chairs in the room, and he'll get in his chair and sit at the foot of the bed for a few hours.
Did he ever wake up screaming as if he had
Yes, sir, he did.
At some point, did Mr. Segura talk to you about the fact that there were only 2 people at the house initially, but 2 more people came home?
No, sir, he didn't. I can't recall that.
Remember talking to law enforcement officers back in November of 2011 when they came to see you?
Yes, I think, one of the ages, I can't,
Mr. Investigator Boccio, is that right?
yes.
All the time?
Vincent?
Yes.
Yes, sir.
Would help refresh your recollection if I showed you a copy of the report that contained the information you had?
Yes, sir.
Very first one. Without reading this, read this to yourself out loud. Does that help refresh your recollection?
Yes, sir.
Do you remember that? You remember anything about him saying anything about somebody being home and then 2 other people coming home?
If I can't recall, it was a while ago, but,
Well, don't guess. If you recall or you don't.
I don't,
Doesn't refresh your recollection?
no, sir.
You said that Mrs. Segura said he put the gun in the car. He tell you anything about where in the car?
Yes, sir, in the motor of the car.
Okay. In the motor?
Yes,
Go
sir.
ahead.
Okay. Did he say anything?
Can we approach real quick, please? Hey, keep going. Matt?
No, I think he just told me it was a car sitting in his yard at his White House, him and his White House or something, and the car was there.
Okay. And he put it in the motor, in the actual motor or the motor area?
In the motor area, I guess, because I don't think you can put a gun in the actual motor.
That's why I asked the question. Thank you, sir. No, go for it.
Keep going.
Collect the transcript.
Yeah.
There were another couple of questions after that we can't show you on the video, but I'll just read the question and answer these. Said, did Mr. Segura tell you anything about the type of gun he used? The witness said, I think, if I'm not mistaken, and I could be wrong, but I think it was like a 9mm or something. And then the question was, but it was a pistol, is that what you're saying? The witness indicated, yes, sir. Then there was a question, I guess that would have been a semi-automatic then, right? The witness said, I'm not really too familiar with guns, so I don't know the difference between them like that. The question, you don't know about whether 9mm come as revolvers, you only know that it was 9mm. The witness answered yes. So that was the testimony, further testimony presented by Mr. Kinard. There is a stipulation from the parties that followed as to Mr. Kinard, said that Mr. Kinard was called upon by the state at an earlier stage of these proceedings to testify before the court. At that time, Mr. Kinard was serving a federal prison sentence. Following his testimony in this case, Mr. Kinard received a sentence reduction for having cooperated with the state. We also are going to present a short clip from, forget whether it's Lieutenant or Sergeant Boccio. It's a very short segment. This would be, rather than require him to come back up here, we're just going to provide we do have this on the video of his brief testimony on this subject. This would have been testimony elicited by the defense.
And Your Honor, also I have, it's already been introduced into evidence as to Exhibit 135, which is the document that indicates that Mr. Kinard and Mr. Segura were in fact in federal custody at the same location in Oklahoma City.
I do.
You have a seat. Slide up the next one, please. Detective Boston, could you introduce yourself? First and last name for the court reporter.
Sure. My name is Sergeant Vincent Boccio. My first name is V as in Victor, I-N-C-E-N-T. My last name is Boccio, B as in boy, O-C-C-I-O.
Detective Boston, you were the one, along with Henry Johnson, who went to Texas at some point during the investigation of this case to meet with Kelsey Kinard, correct?
That is correct.
Okay. And because he was in a federal correctional institution, you weren't able to bring in recording equipment, is that right?
That's correct.
Okay. You recall that conversation that you had with Mr. Kinard at the time?
Yes.
Okay. And in recounting the details of the murder as he claimed that Mr. Segura gave them to him, did he at any point ever mention anything about children?
No.
Okay. Was he able to give you any specific details about how the offense was committed back then?
No.
In this situation also, let's talk also about Mr. Kinard. Questions were asked of Kelsey Kinard in your interview there about whether or not he identified kids specifically. Isn't it true that Mr. Kinard stated to you or told you that Mr. Segura said, or I guess Mr. Kinard told you that Mr. Segura said that there was a quadruple homicide, meaning multiple persons?
That's correct.
Okay. That he told you that he killed 2 people there initially, but 2 others came home.
Yes.
So a total of 4.
That's correct.
Okay. So it wasn't that he didn't tell you there weren't multiple people, he just didn't tell you the age of the people.
That's correct.
Okay.
Pretty great.
All right, let's go Sample. Okay, so that's what we got for the day. As I said, earlier I told you we had one witness that had a scheduling problem today, but he was going to have to be followed by another witness. We weren't going to get all that done today anyway, unless we wanted to go till 7 o'clock. I don't think we want to go till 7 o'clock Friday night. So anyway, we're going to break for the day. Monday morning, we're going to have 2 witnesses. They're both reconstruction experts. There's one for the defense, one for the state. I would hope we would be through with the testimony by about lunchtime on Monday. You know, these lawyers are going to have all weekend to think about this, so they might surprise us on Monday morning, but that's what I'm expecting. And we'll probably break at that point in time and come back and do the instructions and closing first thing on Tuesday morning. You may wonder why we don't just, you know, keep it going and get it done, but We don't want to be sending you out to start deliberating at 6 o'clock in the evening. That's not fair to the case or fair to y'all. That's late. So we're going to try to get it to you on Tuesday by lunchtime so that you have plenty of time to discuss it. As I've warned you, I don't know whether that concerns you or not, but warned you, if you don't get a verdict on Tuesday during the day, we will sequester you Tuesday night. You'll be staying in a hotel. So just be aware that's a possibility. So what I'll have you do when you come in Tuesday is just bring an overnight bag with you in case that happens. So that's the current layout and plan of where we are. I think we're on track. Lawyers have been cooperating to keep things moving. So it's been well done. Appreciate that they're cooperating with each other and keeping things going. So anybody have questions, what's expected of you? If not, we'll see you Monday morning, 8:45, same procedure. All right, everybody be seated, please. But may have been a little short with it earlier, but had the jury waiting, so I thought I should explain my ruling on what the defense raised about Pint. I forget what her real name is, but I asked the state to cooperate with letting the defense call their witness on Monday by going ahead and starting their rebuttal. Part of the deal with that is we couldn't then be doing rebuttal to their rebuttal just because of the timing of it. Frankly, I was prepared to say Mr. Knox could testify today or not. Y'all agreed to the contrary, which I think is good and admirable that you're getting along professionally and working in that way. But I don't think the state can be penalized by the way it's been done, making it look like it wasn't a big deal to call in another witness, but actually what that would have been would be some type of rebuttal, and I'm not going to get into that. Then the state would want to say, well, we have rebuttal to that, and I just think it's a never-ending chain. So that's the basis of my ruling. If you want to put the lady's correct name on the record, you can do so, Mr. Prince.
Yes, sir, and I was going to ask the court too, I don't even necessarily need the court to remain as you've already ruled, but I was going to see if the court had any objection to me preserving what that testimony would have been.
Right, I thought you did that.
Okay.
She was going to say that she knew that the children were killed in the tub, I think is what you said.
Yes, sir, and then she conveyed that to Mr. Segura on November 20th, 2000.
Right. And what was her name?
Marguerite Douglas.
Okay. All right, so I just wanted to explain my ruling.
Yes.
All right, what else we have to take up?
Nothing else from the defense, Your Honor.
Anything else?
Yeah, just to maintain the record, Your Honor, there was an interview with her, and this is supports of the tit for tat, Your Honor, I was just talking about that would have occurred. But the bottom line is, I believe what her previous testimony during that interview was that that she initially told them that somebody had killed them, the two kids and her, and kidnapped the little boy. Later on, she had found out they found the 4 bodies. And after she had talked to Mr. Segura, she later found out at the grocery store. So it just supports that we need to be going back and forth at that point.
Well, I mean, do you think we need to have a record proper from her? I mean, do you
No,
doubt what Mr. Prince is saying.
No, Your Honor, I
saying
think that right there is on the
Okay.
record, and I think we'll be sufficient.
Okay, all right, anything else? So we're gonna be ready to, present Mr. Knox at 9 o'clock on Monday morning, correct, Mr. Prince?
That's correct, Your Honor.
All right, and you're gonna have,
Mr.
Mr. Yao here ready to roll.
Yes, Your Honor, he actually will be asking that he be in the courtroom to observe the other
Okay,
witness testimony.
and, I assume both y'all have the jury instruction from last time.
I'll dig them up.
Because we're gonna get into discussing that Monday, so that we can have that worked out on Monday. I don't
can't
know if
anticipate.
anybody thought of anything unique. You're going to be seeking in a way a jury instruction.
I don't think we're gonna be looking for anything different, Your Honor.
Yes, Your Honor, I agree, I think they'll be the same.
Okay, all right. Y'all have a good weekend. We'll see you Monday morning.